Good morning, everyone. Welcome to our webinar this morning, Hot Topics in Data Protection. This is the third in the series of webinars that we're running this autumn in place of our usual in-person Think House Foundations events. My name is Natalie Barton-Howes and I'm one of the co-chairs of Think House Foundations. I'm a principal associate in the commercial litigation team here at Gowling WRG. As you've joined us here today, you probably know that Think House Foundations is our programme aimed at in-house lawyers at the more junior end, ranging from trainees and paralegals up to lawyers around 5 years PQE. But we do still welcome you if this area is new to you or if you're looking for a refresher. You might already have dialed into the two webinars that we've had already this week. The first was a litigation survival guide webinar on Tuesday that was delivered by my teammate Anna Lelliot, from the commercial litigation team. And then yesterday we had a webinar delivered by my colleague Jasmine Coynes from the employment team, and that was on the topic of returning to the office, the old norm. If you weren't able to catch those webinars live, then don't worry, as we'll be sending out recordings in the near future, hopefully next week. So onto the topic for today's webinar, Hot Topics in Data Protection. I'm joined by Claire Van Ristel, a senior associate in our commercial IT and outsourcing team. Claire is going to take you through the basics, highlight some of the recent changes in data protection and offer you some practical tips and takeaways from today's session. As many of you will know, data protection law is constantly evolving, and as in-house counsel, you have to stay up to date. The webinar is going to cover recent developments in data protection, including international transfers and updated guidance from the ICO. Claire's going to speak for around 25 to 30 minutes, and then we'll have time for questions at the end, and we'll draw the webinar to a close at around 11:15. Before I hand over to Claire, I have a couple of housekeeping points to run through. So firstly, if you would like to ask a question, we are using the Q&A function, which you will find at the bottom of your screen. So just click on that and type in your question, and it will be directed to the panel only, which is Claire and I. Other webinar attenders won't be able to see them. So there's no such thing as a silly question, and Claire and I will do our best to deal with as many questions as possible at the end before we close. So I can't guarantee that we'll get to all of them, but we'll certainly do our best. And if you leave your contact details, we can always follow up directly after the webinar. Secondly, this webinar will be recorded and you will be sent an email with the recording, so do feel free to share that amongst your colleagues when it arrives. Finally, at the end of the webinar, there will be a link in your browser to complete a very short feedback questionnaire on this webinar. Please do take a couple of minutes if you can to fill that in and send it back to us. We do read them and your feedback will help to shape future sessions. Our next session is in the spring, so we'd be very grateful if you could do that for us. We'll also send a link to complete the feedback when we circulate the recording of this webinar, in case you don't have time to do it today. So that's all from me for now. I will hand over to Claire and leave you in her capable hands.
Natalie, and thank you to you all for attending this morning's Think House Foundations webinar on data protection hot topics. So today I thought we'd have a look at some hot topics in the world of data protection. But first of all, I thought it'd be useful to start by having a quick look at the data protection regimes currently in place and some key terminology by way of a refresher. We'll then have a look at international data transfers from the UK and the EU. And finally, we're going to finish up by having a quick look at some other hot topics and things to keep an eye on. So the data protection regime currently in place in respect of the use of personal data is the GDPR in the EU, which you'll all be very familiar with, and the UK Data Protection Act and the UK GDPR here in the UK. In terms of e-privacy, the Privacy and Electronic Communications Regulations 2003, or PECR, are currently in force, but will be replaced with new e-privacy regulation, which I'll touch upon later. While we go through the session this morning, you'll hear me using some keywords that you'll be able to see on the slide in front of you. So when we talk about personal data, this is any information relating to a data subject. So anything that can identify you, such as your name, age, address, ID number, national insurance number, customer reference number, etc. Special categories of personal data. This is personal data relating to health, ethnicity, religion, sexual orientation, political opinion, genetics, biometrics, or trade union data. And since an unauthorized disclosure of these types of data can cause much more damage to individuals than regular personal data, the rules around the use of them are more strict. If you employ staff, you'll most definitely be processing special category personal data, such as health data for the purpose of recording sickness or absence or health insurance purposes. And you may also collect other data for the purposes of monitoring equal opportunities, such as religion, ethnicity, and sexual orientation. When we talk about data subjects, a data subject is an identified or identifiable living individual. So these could be your customers, your employees, your contractors, although it doesn't include deceased people or a person who cannot be identified or distinguished from others. What is a data controller? So a controller of data will determine the purpose for which and the manner in which personal data is processed. You can also have a joint controller scenario whereby 2 or more controllers jointly determine the purpose and means of processing. And coming back to the employment scenario, your employer will be the data controller of the personal data it collects from you as part of the employment process. It will collect your name, your address, your date of birth, your national insurance number, and your bank details, for example. A data processor processes personal data on behalf of the controller. So if your employer collects your bank details from you, it will then most likely pass these on to a third-party service provider of payroll services. This payroll provider will be a data processor, processing your personal data on the instructions of your employer, the controller. And when we talk about processing, this is a really wide definition that includes any operation that can be performed on personal data, including collecting, storing, analysing, or deleting. So as we've just talked about, your employer will process your data by collecting it and storing it and transferring it to the payroll provider, who in turn will then process your personal data for the purpose of ensuring you get paid. Now, especially when we come to talk about international transfers, I'm going to speak about third countries. So these are states that fall outside of the GDPR zone, being EU member states, plus Norway, Liechtenstein, and Iceland. The GDPR restricts transfers of personal data to third countries unless personal data is protected in another way, or an exception applies to that transfer. And again, when we come to talk about international transfers, I'll be referring to adequacy. So this is a term that the EU uses to describe other countries, territories, sectors, or international organisation that it deems to provide an essentially equivalent level of data protection to that which exists within the EU. So moving on, one of the hottest topics this year was the update to the EU standard contractual clauses and the international transfer regime in the EU. So starting off with data transfers from the EU to the UK. So following from Brexit, the UK became a third country under a different data protection regime. A decision was made on the 28th of June this year to grant the UK adequacy. So the EU have decided that the UK has an essentially equivalent level of data protection to the EU, and that data can continue to flow freely from the EU to the UK without the need for any further safeguarding mechanisms. However, this isn't permanent and could be withdrawn in the future depending on the developments with UK data protection law and how far this diverges from the EU regime. At the minute, it aligns with GDPR, but this was going to be a constant one to watch. Interestingly, there's also an automatic sunset clause for UK adequacy to expire in 4 years' time. So keep your internal documentation detailing your data flows, which I'll refer to as data maps, up to date so you know where your data is going and what additional safeguarding mechanisms you may need to implement in the future if the adequacy decision were to change. Moving on to EU to third country data transfers, you may be aware that a new set of updated EU SCCs, that's standard contractual clauses, have been published. And now, just in case you're not familiar with SCCs, they're one method by which data can be transferred outside of the EU to those states which haven't been granted adequacy, for example, the USA, and they add an added level of protection. On the 4th of June of this year, a new set of updated EU SCCs were approved by the EU Commission, which addressed deficiencies in the old SCCs, which predated the GDPR and which are out of date with the current data protection regime. As of a few weeks ago, on the 27th of September, these new SCCs are now mandatory, and organisations will have until December 2022 to repaper the old style SCCs onto the new EU SCCs. And just to tell you a bit about the new style SCCs, these SCCs have inbuilt Schrems II clauses, which means that they have provisions to cover potential requests by third countries' governments or authorities to access personal data transferred. For anyone not familiar with the Schrems II case, I'm going to talk a little bit more about it in a few minutes. They also have inbuilt template controller to processor clauses. You might know these as Article 28 GDPR clauses, which once completed by the parties should negate the need for separate data processing agreement to be put in place between a controller exporter and a processor importer of the data. There's also 4 varieties or modules available, so you can tailor your SCCs. There are controller to controller module, controller to processor, processor to processor, and processor to controller, excuse me. There's also an optional docking clause at clause 5, which means that other parties can become a party to the SCCs, either as a data importer or data exporter, simply by signing Annex 1A. So even if you don't have an additional party to add at the point at which you're agreeing your SCCs with your processor or controller organization, we do recommend leaving this clause 5 in case it's needed for the future. For example, you may be a processor organization, and just to simplify things, I'll use the payroll provider example we talked about earlier. You may want to appoint a sub-processor to carry out some of your processing activities. You could use the docking clause to make your sub-processor a party to the SCCs. So those new EU SCCs will only apply to international data transfers from the EU. So it's really important to understand how the landscape is changing here in the UK too. Where are we now? Just by way of background of some recent developments that have taken us up to where we are now with the transfers from the UK. In July 2020, with the Schrems II judgment, which I referred to earlier. So this was really high profile, and this was a case in which the UK Justice of the European Union, that's the CJEU, invalidated the EU-US Privacy Shield. And for anyone not familiar with what that was, it was a framework for regulating transatlantic exchanges of personal data for commercial purposes between the EU and the US. And the court confirmed that the validity of the EU's SCCs, but it required exporting entities to carry out a risk assessment on a case-by-case basis to verify whether the SCCs provided an adequate level of protection for the personal data transferred, and to implement additional safeguards where that was not the case. And of course, we had Brexit. So the transition period ended on 31st of December last year, meaning that on the 1st of January 2021, the UK became a third country with its own data protection laws, that being the Data Protection Act 2018 and the UK GDPR. So this is the retained domestic law, which sits alongside the DPA. Key principles, rights and obligations remain closely aligned with the GDPR. In June 2021, as I mentioned, we had the updated standard contractual clauses from the EU. These were updated in light of GDPR and Schrems II and address a wider range of scenarios. However, as a result of Brexit, the revised SCCs don't apply here in the UK, and the UK must implement its own SCCs. But at the minute, we don't have any. So as a temporary measure, at the moment, UK organisations are permitted to use the old style SCCs as a transfer mechanism and to make changes to them so they make sense in a UK context. So provided you don't change the legal meaning of the SCCs, you can make common sense changes like changing references from the old EU data protection to the UK GDPR, changing references to the EU or member states to the UK, and changing references from a supervisory authority to the ICO. But we don't even need to do this at the minute because the ICO has helpfully created a UK version of the SCCs with guidance. And the UK suggested changes already made. So if you do need to do any restricted transfers, we recommend you go onto the ICO website for that information. You need to carry out the transfer. Using the old SCCs in this way is only going to be a temporary measure, and the ICO must publish its own set of SCCs under the UK GDPR. So as part of that process, on the 11th of August this year, the ICO launched its consultation on its draft International Data Transfer Agreement, which I'll refer to throughout as an IDTA, and also guidance for organisations on international transfers, which then will replace the EU SCCs. The consultation closed on the 11th of October, and once the IDTA is finalised, it's that's going to replace the EU SCCs here in the UK. So I'll chat through that in a few more details in a minute, but I thought it would just be useful to mention at this point the influence of the UK government in the development of the new transfer regime here in the UK. So there's most definitely a political angle in the changes to the UK data law. The Department for Digital Culture, Media and Sport, that's DCMS, is looking to make the existing rules governing data transfers of personal data to the UK from the UK to third countries more proportionate, flexible and interoperable. And you'll see from the slide there's a lot of talk about building trust, delivering growth and firing up innovation when it comes to this IDTA. The proposed changes could include, amongst other things, empowering organisations to develop and self-approve their own transfer mechanisms as opposed to relying on existing standards, and allowing non-UK bodies to develop accredited international certification schemes, which can be relied upon by UK companies to facilitate the free flow of data. The Secretary of State may also be granted power to introduce or approve new transfer mechanisms from time to time. So all in all, it's something a bit more flexible and a bit less rigid than the EU position. It's also worth remembering that all of these reforms will only apply and govern the transfer of personal data, which is subject to the UK GDPR, and the EU GDPR regime will continue to run separately in parallel. And this is really important to remember. For example, your organisation is transferring personal data belonging to employees to a service provider who may be in the US, and you have UK employee and EU employee data to transfer. You'll need to ensure you're following and implementing the UK regime in respect of UK employee data, and then separately the EU regime in respect of the EU employee data. So you'll have two sets of data transfer mechanisms in place and running at the same time. So just to talk to you a bit further about the ICO consultation on data transfer, what was this all about? Well, the ICO split this into three different sections. So they set out their proposal and plans for updates to guidance on international transfers. They also set out a proposed transfer risk assessment tool, a TRA, which need to be carried out. And then they published a draft international data transfer agreement, which would be the replacement for the SCCs. So just turning to the guidance, the consultation sought input on questions around the transfer of personal data, but also included broader questions relating to the scope of the UK GDPR, legal, economic and policy considerations and implications. So it looked like the ICO was very much looking at the international transfers in the round. The TRA produced by the ICO is supposed to be used to assist organisations when making routine transfers, although organisations are also going to be free to use their own methods to assess risk. And we're going to come on to the TRAs in a bit more detail shortly. Finally, the ICO issued a draft of the International Data Transfer Agreement. It's got a simple layout, it's got guidance, and it looks a bit more user-friendly than the EU SCCs. So what is the TRA that the ICO is proposing? In advance of making any international data transfer from the UK, a risk assessment will need to be carried out. So organisations will need to make sure that the IDTA works as they intended to in the country where the receiver of the data is based. So the ICO's intention is that the TRA will check that the local laws and practices don't override the protection provided by the IDTA. This is going to be a three-stage process for assessing the risk. First of all, you need to decide, is the tool suitable for the transfer? You'll then need to understand, is the IDTA enforceable in the destination country? And then you'll have to do an assessment of the destination country's regime for regulating third-party access to personal data, including an assessment of surveillance laws. And organisations will really need to show that they've used their best efforts to complete a TRA when relying on the use of the IDTA as their safeguarding mechanism. Although, as I said, it doesn't have to be the ICO's TRA that is used, you can use your own. Moving on to the IDTA itself, this is an agreement to be entered into between the exporter and importer of the data, just like the SCCs. But again, it doesn't seem to be as rigid as the EU SCCs. There's an option to include extra data protection clauses. For example, when you complete your TRA, you may decide the IDTA needs extra steps in order to provide the right level of protection. There's also an option to include commercial clauses agreed between the data exporter and importer, provided that these don't contradict the IDTA. And when you transfer data, you'll often have another agreement in place with the other party. For example, you may have a service agreement, a data sharing agreement, or data processing agreement in place. Under the IDTA, these are referred to as linked agreements, as they link to the transfer you're making. They'll often contain a lot of the same information you'll need to complete the tables in the IDTA, so you can actually refer back to the relevant sections of the linked agreements when needed, rather than just repeating them verbatim. The IDTA can also be a multi-party agreement, and under a multi-party IDTA, someone may be nominated to make decisions on everybody's behalf. Again, this is granting a different level of flexibility to that seen in the SCCs. We're going to have to watch this space to see what the outcome of the consultation will be, what the final IDTA will look like, and when the new transfer regime will come into force, but it's definitely one we're keeping an eye on. Just a wee note on adequacy. So now that we've left the European Union, the UK government is able to independently determine whether, for the purposes of the UK GDPR, a third country is adequate. and that personal data can be transferred to that jurisdiction in question without the need for additional transfer mechanisms. So why are the government so excited about this? Well, their belief is that by making it easier to transfer personal data, it's going to be easier for organisations to do business, which will in turn have a positive impact on the economy. Great for us all. UK decisions of adequacy will be granted by Secretary of State. So as well as determining whether a country is adequate, the Secretary of State is also going to be able to designate territories within a country, sectors of an economy, or even international organisations as adequate. The UK government has identified a number of priority territories that it wishes to strike data partnerships with. So you'll see those on the slide. They're Australia, Colombia, Dubai International Finance Centre, the Republic of Korea, Singapore, and the USA. The government estimates that data-enabled services to these jurisdictions alone are worth around £80 billion. There's also going to be a secondary list of longer-term priorities. So these are Brazil, Kenya, India, and Indonesia. And I thought it was also worth noting that the UK government is going to award adequacy to those jurisdictions that the EU Commission deems adequate. So what does all this mean for your organisation and how you transfer personal data? Whether you're transferring data from the EU or the UK, it's all change. So when transferring personal data from the EU to a third country, you're going to need to use the new EU SECs to implement that transfer, and you're going to need to make sure that you repaper any old-style SECs before December 2022. For transfers from the UK, there's new IDTA on the cards, so we're going to need to watch this space and just use the old-style EU SECs found on the ICO website for now. And we really recommend that organisations understand how their international data flows. So you need to carry out your data mapping exercises. And for anyone not familiar with this, it's like an audit of your data flows. You need to know where you're collecting data, who from, what categories of data subject, how you're processing it, and how you're transferring it to third parties or out of the jurisdiction. And you need to keep this up to date. If you're required to do so, you need to put in place appropriate data transfer mechanisms. And you also need to remember that there are currently 2 separate data protection regimes now in place for the UK and the EU following Brexit. So what about the other hot topics around data protection right now? As I mentioned, we have the privacy regulation. So this is a successor to PECR. It should have come in force with the GDPR as it's been in negotiation from 2017, but there's been some delays. And just for anyone not familiar with PECR, the regulations give data subjects specific privacy rights in relation to electronic communications. So there are specific rules around marketing calls, emails and texts and cookies and similar technologies, and on other things like customer privacy as regards to traffic and location data, for example. The e-privacy regulation will update the e-privacy directive to bring it in line with the GDPR, because at the minute, although PECR sits alongside the DPA and the UK GDPR, it's really out of date. The regulation will also have extraterritorial applications. So it's going to apply to business outside of the EU insofar as it relates to end users in the EU, but it doesn't require that EU users are specifically targeted. And just some key highlights about the new regulation to let you know about. It's going to have a broader remit than just cookies and websites. It's going to have application to Internet of Things solutions, machine to machine, and over-the-top media services. The hope is that it will address cookie consent fatigue. So consent is going to be pushed back to the browser settings rather than collected at every website, but browsers need to be developed to make that happen, as currently the functionality isn't in place. Users who have given consent will also need to be reminded every 12 months of the right to withdraw that consent. Of course, the regulation is only going to apply in Europe and it won't automatically apply here in the UK. But cookies are an issue gaining prominence in the UK, and at the G7 summit in September, the ICO did raise cookies as a key topic on which more global cooperation is needed. There's also been an increasing number of complaints about cookies to the ICO. So I think there's been around 2,000 in the past year, and we're definitely seeing more claims coming through our door relating to breaches of PECR related to cookie policies. It's anticipated that the e-privacy regulation won't come into force before 2023, and that there will be a potential transitional period of 24 months, meaning that any new regulations would not then come into effect before 2025. So it's a bit of a way off just yet. The UK not following suit with the EU on this matter has the potential to affect our adequacy decision. So I would imagine that PECR will also be updated and brought in line with the UK GDPR. Also, because of the extraterritorial application of the e-privacy regulation, it's going to effectively apply to all UK businesses as regards to end users in the EU. So it may have implications for your organisation in an event. So it's definitely one that we need to keep an eye on for sure. And just before we finish up, I wanted to let you know about a few more hot topics that you'll see I've set out in the slide there. So we have the ICO Data Sharing Code of Practice. This is a statutory code that came in force in December 2020. It was an update to the ICO's first data sharing code from 2011, so it was well overdue a refresh. It covers all different types of sharing, from controller to processor, controller to controller, joint controller, and multi-party sharing. It highlights the importance of documentation for accountability and carrying out DPIAs, that is data protection impact assessments. It sets out some really useful checklists at Annex A, and it's really worth reviewing if you haven't already. You can find this on the ICO's website. The ICO have also recently issued the Children's Code, or the Age Appropriate Design Code. So this is another statutory code of practice. And according to the ICO, 1 in 5 UK internet users are children, but they're using an internet that wasn't designed for them. So the ICO have set out in this code 15 standards that online services need to follow in order to ensure they're complying with their obligations under data protection law to protect children's data online, to provide built-in protection to allow children to explore, learn, and play online. Settings must be high privacy by default. Only the minimum amount of personal data should be collected and retained. Children's data shouldn't be shared, and geolocation services should be switched off by default. The online services covered by the code are wide-ranging and include apps, games, connected toys and devices, and news services. But if children are likely to access your service, even if they're not your target audience or user, then you do need to consider the Children's Code. It's important to note that the code applies to UK-based companies and non-UK companies who process personal data of UK children. So moving on to the AI toolkit. So artificial intelligence is a continued area of focus in the world of data protection. In July, the ICO introduced a new beta version of its AI and data protection risk toolkit. So this contains risk statements to help organizations using AI to process personal data, to understand the risks to individuals' information rights. It provides suggestions on best practice and organizational technical measures that could be used to manage or mitigate the risks, and it demonstrates compliance with data protection laws. The ICO has guidance on AI and data protection, which they've co-badged with the Alan Turing Institute. So that's UK's National Institute for Data Science and AI. They've split this into 3 parts. It's over 200 pages long and it's very, very detailed. So it's some light reading if you are interested in AI at all. And finally, just want to touch upon the AdTech investigation. So you may have heard about this. It's an investigation into the real-time bidding and the ad tech industry, which is largely driven by cookies, some of which are highly privacy invasive. So this investigation was suspended during the pandemic, but it restarted as of February this year. Just to let you know, real-time bidding uses people's special category data to serve adverts and requires people's explicit consent to do so, which is not happening in the industry at the minute. So sharing people's personal data without properly assessing or addressing the risks raises questions around the security and retention of that personal data. The ICO have advised all organisations operating in the ad tech space to assess how they use personal data as a matter of urgency. The intrusive nature of the technology makes it a real priority area for regulators, and it's likely that the massively complex ad tech industry will have to adapt and provide much higher levels of transparency follow the outcome of this investigation. So I hope that's been a useful whistle-stop tour through international data transfers and some other hot topics. And I think we might now have some time for some questions, Natalie.
Yes, we do. Yeah, thank you, Claire. That's really interesting and lots of a lot for everyone to be thinking about, I think there. We have had some questions. One that I suspect probably comes up a lot is, does the GDPR still apply in the UK?
Yes, so technically UK GDPR, or the GDPR is an EU regulation, but it does apply in the UK by virtue of the UK GDPR, which is a retained domestic law that we retained following Brexit. So due to the legislation around Brexit, we have retained law, and the principles are still the same. It's set out as the UK GDPR. There are some nuances. But yes, the principles are still the same. We still refer back to Article 28 clauses, etc., 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 etc. So yeah, it still applies.
Thank you. So when is the UK International Data Transfer Agreement going to come into force? And what do we do in the meantime? Do we just continue using the old SCCs?
Yes, well, the ICO have said that they do want to try to have this new data transfer regime in place for 2021. As I mentioned, the consultation closed just on the 11th of October. So they're going to take on board all the feedback on the consultation. They'll then have to do what they need to do if they need to rejig the formatting of the IDTA or the transfer risk assessment tool. So I know the intention of the ICO was to put those, those tools in place by the end of this year. If it doesn't happen, hopefully it will be shortly into 2022. And yes, in the meantime, we just continue to use the old style EU SCCs. The ICO have amended these on their website. They are available there. There's guidance alongside as to how to fill them in, and they're very useful. So that's what we would have been using for our clients if they need to effect international restricted transfers in advance of that IDTA coming into force, yes.
Okay, and so what happens if a data subject has dual nationality? Which laws will apply?
Oh, that is a really interesting one, and I think that's something I'm going to have to go back and have a think about.
I suppose there's no context there, is it, in terms of?
Yeah, and I suppose it will depend as well in the context in which their data is being processed. So are they, say, a Spanish employee employed in the UK with a UK employer? So they're not being targeted in the EU, if you know what I mean. But it's definitely one I'd have to think about and want to come back and advise on properly, knowing the context.
Yeah, so we can definitely do that. We can follow up with the person who's asked that question if there's context around it and if that's something you want us to do. Another question is around if a country has adequacy status, are any contractual clauses still required?
So if you've got adequacy, you can freely transfer data. So the EU, and then as well following Brexit, the UK government have said that any countries that were already adequate for the EU Commission, they will now be adequate in terms of UK data transfers too. So you can continue to transfer data without additional safeguards. Obviously, if you do have any concerns about your data processor in that country or anything else, if they can't offer you the safeguarding mechanisms that you expect to see in place, etc., then do your due diligence. But in terms of if they're an adequate country, yes, then they shouldn't need any additional safeguarding mechanisms.
Okay, that's really useful to understand. I've got another question here. It says, what would you advise a UK controller puts in place if sending data to a UK processor who then uses a sub-processor in a third country? That's not too technical. Is it the responsibility of the processor to have the SCCs in place with the sub-processor and any additional measures?
Yes, so that processor should have in place the contractual arrangements, the safeguarding mechanisms it needs to be able to transfer that data outside of the UK.
Okay, that's a nice short answer to quite a long question there.
If I haven't answered the question appropriately for the requester, please do leave us your details and I can get back to you on that one.
Okay, well, we've got time for one more, I think. Does viewing data constitute processing?
I think, again, I'd need to consider the context of how the data is being viewed and come back to that question specifically, knowing further information about that.
Okay, all right. Well, I think on that note, any further questions that are quite specific, please send them through still, but I think that would be a follow-up situation if there are many questions. So thank you. I think we've got through everything we needed to get through today. So I'm going to draw the webinar to a close. As I said at the beginning, we do hope that you have enjoyed our autumn webinar series for the Think House Foundations programme. Fingers crossed, we'll be back in person in 2022. Before I close, as I mentioned before, if you do have time to fill in those feedback questionnaires, then please do that if you can. So thank you very much, everyone, for watching today, and have a great day.
Bye-bye. Thank you.